Hey everybody, welcome back to the channel. I appreciate your time. Thank you for watching. I was sent this court document several times last night by many people, many viewers. Thank you. And this is a challenge to the NFA. That's right, you've heard it. The NFA is being called out in a pre-existing court case, one that we've talked about here on the channel before, and that is the case against Matt Hoover and the auto keycard case. So what I'm going to do is show you the document. I'll give you a quick synopsis of each page. It's 9 pages in total. I think it's important that we look at this together and see what it is, because I know we're going to hear all kinds of things that it's not. And I want people to have the knowledge and have it right from the court document so that we can be deadly accurate in what we're talking about. So here on the screen is the case in question. This was filed on July 1st, and this is in the case of the United States of America versus Matt Hoover. And this is a motion to dismiss and declare unconstitutional the National Firearms Act of 1934. This is looking to dismiss all 7 counts of the indictment against Matt Hoover, and you can see it ties right into the Bruen decision. We'll go down to number 1. The Supreme Court's landmark Bruen decision fundamentally changes the instant matter. It says, it talks about how the New York State Rifle and Pistol Association versus Bruen opinion struck down as unconstitutional New York's Sullivan Act from 1911. And that's what the proper cause standard came from to get a license to carry a concealed firearm. It goes on to say that the 2-step framework for analyzing the Second Amendment challenges, that combines history with the means and scrutiny, and how that was deemed unconstitutional, and how the court said that that was 1 step too many. It also says these previous decisions at the various courts of appeal manifested deference to the government in a matter unlike any other fundamental right, and the inexplicable consideration of regulations clearly contemplating the keeping and bearing of arms as beyond the scope of the Second Amendment. Then the last paragraph here on the second page says, finally though, we have a standard which clearly articulates the burdens in a case involving restrictions on the right to keep and bear arms. It is, as artfully penned by the court, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Only then may a court conclude that an individual's conduct falls outside of the Second Amendment's unqualified command. To summarize, any law, regulation, or government policy affecting the right of the people to keep and bear arms can only be constitutional if the government demonstrates analogous restrictions deeply rooted in American history, evinced by historical materials contemporaneous with the adoption of the Bill of Rights. So, basically, it is not in the text of the Second Amendment, nor does it fall within the history or the tradition of firearms here in America, and they're referencing the NFA, the National Firearms Act, you know, that little thing that keeps the ATF in business. B, the statutes here at issue affect conduct covered by the Second Amendment's unqualified command. The defendant is charged under 18 U.S.C. 5861 and 5871, as well as conspiracy to commit those offenses. The charged statutes deal with the taxation and transfer of machine guns and other weapons. The government alleges the auto key cards are machine guns. What's more, actions subsequent to the passage of the charged firearm statutes render it impossible to comply with the taxing provisions. The government may attempt to argue that machine guns are beyond the scope of the Second Amendment by attempting to characterize them as dangerous and unusual, as it has in other cases, but this is not the test. The court's invocation of dangerous and unusual weapons in Heller and subsequently Bruen was for the purpose of discussion of what might be constitutionally acceptable law rather than the endorsement of any particular extant policy. Rather, the only way a court may conclude the defendant's conduct falls outside the scope of the Second Amendment's unqualified command remains clear. The government must prove the particular regime in question is consistent with the history and tradition of the United States. Furthermore, the question of whether a weapon is, quote, in common use at the time, end quote, necessarily pins the analysis to the time before the prohibition. To consider otherwise would incentivize the government to legislate wantonly and aggressively, seizing arms, then later evade constitutional scrutiny by suggesting that the arms cannot be in common use because the government prohibited them. Stick with me, guys. We're on our way home here. C, the laws here at issue are facially unconstitutional under Bruin. I'm going to go about halfway down. Our nation's history and tradition does not and cannot support a finding that an alleged drawing of a part is that part merely because an unelected bureaucrat unilaterally willed it to be. To hold otherwise would be to grant the Bureau more power than Congress could have ever granted it, and make innumerable items potentially illegal. As Bruin explained, historical analogs to a regulation can be helpful, but defendant here proffers more modern evidence that a categorical ban on machine guns, as the government here seeks to enforce against a bespoke trinket, would be unconstitutional. We present the testimony of then Attorney General Cummings at the 1934 hearing on the National Firearms Act. And this is right from that case, guys. Mr. Lewis, I hope the courts will find no doubt on a subject like this, but I was curious to know how we escaped that provision in the Constitution. The Attorney General then, Cummings, said, we do not attempt to escape it. We are dealing with another power, namely the power of taxation and of regulation under the Interstate Commerce Clause. You see, if we made a statute absolutely forbidding any human being to have a machine gun, you might say there is some constitutional question involved. But when you say we will tax the machine gun, and when you say that the absence of a license showing payment of the tax has been made indicates that a crime has been perpetrated, you are easily within the law. And then Mr. Lewis said, in other words, it doesn't amount to a prohibition, but allows of regulation. To which the then AG said, that is the idea. We have studied that very carefully. So they're plain as day from the transcript. They're telling you that they can't say you can't have those because that would be unconstitutional. But if we say you don't have the tax stamp and then make it really, really difficult for you to get that tax stamp, then it's just a regulation. And in 1934, they fell for that hook, line, and sinker. But because the Bruin case was so eloquently penned by Justice Thomas, it's being challenged, and what they're challenging on these grounds are rock solid, at least according to the Bruin decision. We'll jump to the conclusion here, guys, and this is it. The command of the Second Amendment is clear. Under Bruin, consistent with the text of the Constitution and the history and tradition of our great nation, it stands to reason that any regulation affecting the peaceable possession of arms, or in this case, something from which the government alleges an arm may one day be made from, warrants meaningful review. The underlying laws here evaded meaningful scrutiny despite being unprecedented in their severity, and the application thereof to Defendant Hoover, a patriotic American and father who stands accused of talking about a piece of metal with lines drawn on it and faces the complete destruction of his life and livelihood therefrom, demonstrates the severity with which this matter warrants meaningful constitutional review. The standard announced in Bruin gives this court the tools it needs to do so. Wherefore, Defendant Matthew Raymond Hoover respectfully moves this honorable court to dismiss the indictment against him in its entirety with prejudice, to declare the National Firearms Act facially unconstitutional, or, in the alternative, unconstitutional as applied to defendant, and for any further relief that this court deems just and proper. And this was filed by Attorney Zachary Zeremy and our friend Matthew LaRosiere. So guys and gals, that's what a challenge to the NFA looks like, and it looks phenomenal. The way it's written is spot on, and in order for this judge, this court, to say, nah, they're going to trip themselves up with Bruin. So let us continue to watch this. Subscribe to the channel if you want to stay in the know, if you want to know what's going on with this, and I will definitely keep you up to date, because if the NFA were to fall, guys and gals, it would be a wonderful day. Till we see each other again, be safe, stay vigilant, carry a gun to keep you, your friends, your family, your community safe. That's what we were supposed to do from the founding of this country. That's what the documents recognize, and that's what the government wants to stop you from doing. I'll see you in the next one. Take care.